Firstly, Dr. Colin Nicholas is the founder and coordinator of the Center for Orang Asli Concern since its founding in 1989. He is involved in numerous advocacy works and social programs that aim to get Orang Asli rights recognized and respected. He obtained his PhD with distinction in Orang Asli politics, development, and identity from University Malaya in 2000. Indeed, Dr. Colin has written a number of key academic articles and books on issues surrounding the Orang Asli communities. As for our second speaker, Dr. Yogeswaran Subramaniam is a leading lawyer and researcher on Orang Asli land rights. He has represented the Orang Asli communities in several native customary land rights cases in Malaysia. Dr. Yogeswaran received his PhD from the University of New South Wales for his research on Orang Asli land rights and the United Nations Declaration on the Rights of Indigenous Peoples. Being a legal scholar, he has published numerous academic articles on such issues as well. As for our third speaker, Shereen Abigael Ajani is an Orang Asli who is currently studying law at University Malaya. She is from the Temuan tribe in Damansara, Selangor, and is very active in advocating for the rights of the Orang Asli. Shereen is currently interning at the New Zealand High Commission in Kuala Lumpur, whereby she is involved in assisting the High Commission's engagement program with the Orang Asli communities. What are the current legal issues being faced by the Orang Asli in Malaysia?
Okay, so your question was the current issue faced by Orang Asli. I think I'll speak a bit more broadly because I think Colin was supposed to speak a bit more broadly about this. I think currently, of course, the dominant issue is COVID-19. COVID-19, which has hit the world and also, of course, Malaysia, and specifically the group of people we are talking about today, which is and COVID-19, of course, has, in fact, in the case of the Orang Asli, has exposed and I feel aggravated and perhaps even compounded pre-existing issues faced by the Orang Asli. So actually, at an operational level, of course, there are high infection rates among the Orang Asli. There are challenges in the communication and reception of health advice. There's poor vaccine rollout, more poor than other sections of society, and mental health issues as a result of COVID. I think we're all quite familiar about that. The Orang Asli, I think they've. But the point about Orang Asli, they were already facing a lot of issues before this, and they, I will just perhaps give a few examples. They face economic marginalization. Their poverty rate is around 30+%, which is is massive compared to the national poverty rate of 0.4%. Education-wise, they've got an inordinate primary school dropout rate of 30%, and infrastructure-wise as well, 20% of officially recognized villages, which are a term which I'll come back to later, is without clean water supply, and 19% are without electricity supply, and in respect of their land as well, only 25% of officially recognized lands, officially recognized Orang Asli inhabited lands are legally protected, and this is actually a very tiny amount compared to the total area of lands claimed by the Orang Asli. So these are just a few examples of their pre-existing, pre-COVID issues that they were facing. Economically, these high numbers in those high numbers of Orang Asli in the poverty line, under the poverty line, have been hit the hardest, I believe, because they have not been able to rely on their traditional forms of sustenance and subsistence due to earlier and ongoing loss of their customary lands. And a recurring and perennial problem here is the lack of security of tenure for Orang Asli, or perhaps in more simple terms, legal recognition of and protection of Orang Asli customary lands. And this has resulted, and this has resulted in land encroachment, which has apparently gotten worse since the COVID pandemic as well. I'm judging this from the increase in the number of Orang Asli communities looking for legal representation to defend encroachments and to litigate claims for customary land rights post COVID. Just another couple of quick points. Legal issues. In terms of legal issues, I believe the Orang Asli have not been prioritized or sufficiently factored into government policy, laws, policy, and the general development agenda. That, of course, as many of us know, gives primacy to resource extraction and land development for industry and cash crop cultivation, amongst others. So I have just 2 points to make on the law, legal issues. I would say the government can be said, yeah, and it has been said, they have not accorded, or at the very least, prioritized substantive equality for the Orang Asli in respect of constitutional fundamental liberties relating to equality, rights to property, life, and also to an extent freedom of association as contained in Part 2 of the Federal Constitution. I can elaborate, but time is short. But I would say that's the first point legally. Secondly, more broadly, the government has also not adhered to its moral and some would say legal obligation to give sufficient effect to international human rights standards in local laws, policies, and practices, particularly those contained in a very important document when it comes to indigenous rights, which I hope if you don't know about it, you should take the trouble to learn about it. The 2007 United Nations Declaration on the Right of Indigenous People. So there are various standards there, and if one would do a comparative analysis, it's still lacking.
For me, I would like to touch on the fundamental liberties for the Orang Aslis. So this is what I seen so far. Number one is the Orang Asli right to the religion, because as you guys know, there is some kind of forced conversion of Orang Asli by few religious agencies without the Orang Asli consents. For example, back in 2019, there is Kelantan Islamic Affairs and Malay Custom Council, MIC. They said they aims to convert all the Orang Asli within the Kelantan state to Islam within 30 years. And this was a statement made by the Deputy President of the MIC, which is Nik Muhammad Azlan. And he also added that the Islamic Development Department of Malaysia, JAKIM, had more than 100 MIC missionaries and community workers entrusted with looking after the Orang Asli welfare and providing them with an education in the name of religion. So I also quote what he had said back then. Our planning is, if we have 500 people a year, we can evangelize, and God willing, in 30 years, all Orang Asli in the state will be converted. We have a comprehensive evangelization framework for the Orang Asli, including through cooperation with University Malaya, University Kebangsaan Malaysia, UKM. So if reading from this news article cited by this government agency is quite alarming, and it's quite frightening to know that my community were forced to actually convert without their consent. And just because we Orang Asli, we have our own ancestral religion, which mainly consists of spirituality, and we don't really have that kind of official like big like Muslim, Hindu, Christian, and Buddha, and so on. But that doesn't mean that we don't have a religion. We do have a religion that we practice since, you know, forever. And we also believe that every single creation by God has its own spirit, like the spirit of the trees, rivers, stones, forests. And we have our own way of praying. So by having this kind of, encroachment of the Orang Asli fundamental liberties for their right to religion is quite dangerous thing that happening in Malaysia. So, and another thing that I would like to touch on about the right to education. In this case, I would like to say mention about how the Orang Asli children, they don't really have that good access to school, especially now in the COVID-19 time, whereby many of the Orang Asli villages in the rural area, they don't have that kind of facilities, especially computer or internet to actually participate in the online digital learning. And it's going to be very hard for them because even their majority of the parent themselves, they are also not really highly educated, and it's very hard for the parents to oversee the children and teaching the children. And at the same time, I also would like to bring about the cases that happened last time in the Sekolah Kebangsaan Tohoi back in Kelantan, whereby there was a corporal punishment by the teacher, and it was a terrible accident that ever happened to the Orang Asli children and being reported widely in the newspaper, um, whereby at the time there is like about 7 Orang Asli children in boarding school. They're running away from the school hostel because they were scared of being punished by the teacher who caught them bathing at the river near the school several days earlier. And among 7 children, only 2 survived. And those survived, they're still living with their psychological trauma. And there was no justice being brought to the disease, as if the life of Orang Asli children do not matter. And the only solution back in 2019 taken by the government at the time by the minister in the Prime Minister Department, Sir Wat Yamurti said he will raise the Orang Asli community request for a new school closer to the village, nearby the post Simpor Guamusa in Kelantan. But will this help to solve the problem? Or rather than just dissuade from the real problem, which is the corporal punishment by the teacher at the Orang Asli school, which I also have experienced firsthand back in my primary school, which consists of Orang Asli, whereby the teachers, they just use corporal punishment to just, punish all the Orang Asli children who have difficulty in learning, difficulty in calculating mathematics, or even speaking English. That was my time last time. So yeah, I think these are 2 issues that happening apart from the one that mentioned by Dr. Yogas earlier.
Yeah, you asked about the current legal issues being faced by the Orang Asli today, and both Yogesh and Shereen have, they explained the various issues, but of course, if outside of this COVID situation, if you ask Orang Asli what is your biggest issue today, they always say land rights, and that is of course very true, but the issue of land rights or land loss, for example, for the Orang Asli is just the greatest manifestation of one big problem which the Orang Asli face, and that is the lack of recognition. The lack of recognition of the Orang Asli as the indigenous peoples on this land. Because if they are recognized as indigenous peoples, and very clearly, like in Malaysia, the Malays are recognized as the politically dominant people, you get all kinds of rights, rights to your reservation lands, rights to culture, rights to education, quotas in this, quotas and that, and so on. It is because the Orang Asli are not recognized as the indigenous peoples and indigenous peoples in Malaysia that we have issues of documentation, forced conversion or whatever influence conversion and so on. So in line with the United Nations Declaration on Rights of Indigenous Peoples, which Malaysia has accepted or endorsed, and which your guest brought up just now, there are 2 basic fundamental principles which are not being recognized or not being followed in principle, that leads to all these problems we have about which Orang Asli face today, whether legal or not. And this is the right to self-determination, right for the people themselves to decide for themselves what's best for them and what's good for them. And 2, the right to free, prior, and informed consent. When you do not follow these 2 basic principles, then we have all these issues: non-recognition of land, non-recognition of right to religion, right to education, right to life, and so on.
I would like to just address Dr. Collins when he mentioned that the non-recognition of the land or the identity of the Orang Asli as one of the biggest issue. I mean, what do you think is the main reason that, because the Orang Asli has been here for so long, I mean, they should have been recognized, but what has happened in our legal system that it does not happen in that manner, and what should we do to actually address that issue?
The problem of the Orang Asli here, in terms of recognition, is a problem of indigenous peoples the world over. See, when before the colonizers came, before anybody, any newcomers came to this part of the world or the parts of the world where indigenous peoples live, They had their own legal systems, their own social systems, their own ways of doing and living, you see. But when these new people came over, they introduced their own systems, the tolerance system, for example, the legal system, land system, whereby it was always to their benefit. Orang Asli were considered non-existent or parts of the forest. At one time, they were counted together with the elephants and tigers in the forest in terms of the census, and always invisible. It's very clear. The constitution completely leaves out the Orang Asli in terms of people with of special position. You see, so what happened was basically there were people who could be subdued and were subdued because of other interests. So and their rights and their latent or their indigenous knowledge, their indigenous systems were not taken into account because they were seen as kafir, inhuman, uncivilized, primitive, and so on. So we were subject to a kind of racism. The Orang Asli was subject to a kind of racism a long, long time ago, and that's the result of it today.
How about post COVID-19? What are we going through after this? Yes, I admit there are plight of issue of Orang Asli regarding their lands, okay, their education, medicals, okay, and other issues is also not denying, and including economic. So perhaps maybe we could propose to the new government, especially to look on a new what we call as a a social agenda for the Orang Asli, but just not an Orang Asli, but the all minorities in Malaysia as in general, then specifically focus on Orang Asli.
I think there are issues and challenges in the reform of land rights, and I've talked and written about all of this, and I think I'll discuss further. I think it's best I discuss it in the next session. But I want to make one point. I just caught on to one point you raised about minority rights. Now, minority rights, if you look at any international standards, minority rights and indigenous rights overlap, yes. But indigenous rights are actually quite particular given their context and circumstances. So if one were to lump minorities, minority groups, and the Orang Asli, for example, in Peninsular Malaysia together, if you are looking for a good human rights outcome, I don't think it would be appropriate, because their rights, their problems and issues are common. Some of them are common to other minorities, but they have they have other issues such as rights to traditional lands and customary lands, and their connection to the land is also something very, very connection to their local customary land, their communal land and customary land is very, very different from other minority groups. So, for example, the Indians in Malaysia do not have such connections to the land, and it is not. They might need land for agricultural purposes, for commercial purposes, for commodity purposes, but they do not have the connection that the Orang Asli have with the land. And there is also the issue of injustice, suffered by indigenous communities, which is quite peculiar and particular to indigenous communities. I could sit down and explain it to you, but I'll just give you a short answer that the minorities are different. So if there's any initiative to the government, indigenous communities should, the context of indigenous communities should be taken into account when in considering any sort of reform for minority groups.
Legally speaking, the Orang Asli Malaysia have an act, the Aboriginal Peoples Act, that is meant to protect and uplift the interests of the Orang Asli. This act does not cover East Malaysian natives. Should there be an act protecting and uplifting the natives in East Malaysia too? Or do you think common law recognition is adequate?
I would say that the natives of Sabah and Sarawak actually they enjoy a different constitutional position. If we just I'll just stick to legal points as opposed to political points for this point, just to address your question. So they have their own constitutional privileges and their own legal system, jurisdiction in respect of, say, for example, land matters. Um, so I don't know if imposing a federal legislation for the natives of Sabah and Sarawak would be such a good thing. I think, and if one were to study the contents, I think the natives of Sabah and Sarawak would be up in arms, because it's a very, very, I think it gives a even larger stranglehold over it will give a larger stranglehold over the natives than what is what is happening there at the moment. So
Um, yes.
federalize something like this would be different, because the histories are quite different, the legal histories are quite different, the politics is different as well. So I don't think it would be such a good idea, if you ask me honestly.
If we look at the Sanda Federal Court matter in 2017, it seems to suggest that unless these rights of the natives in East Malaysia are recognized by law, they do not seem to have any rights at all. So just wondering what your thoughts are on this. With maybe they don't need a federal legislation, maybe they need something enacted by the states, but still, legally recognized in some form of statute. What do you think?
There are a couple of ways in which this can be done. The mechanics of it, I mean, uh, one would be a statute, as you put it, because it has to be, as Sanda has ruled, it needs to be recognized by law, and they see law in a narrow sense as being something that's put down in written law. But I think it's much more than that. Common law rights or constitutional rights in the case of the natives of Sabah and Sarawak can actually be pursued in the courts as well to force change, perhaps. So if there's anything that can be brought up, it would be politically and as well through the Malaysia Agreement, and also the constitutional rights available to the natives of Sabah and Sarawak, which actually, to be honest, are there. It's just a matter of raising this and actually raising their rights with in the courts and testing them. There have been sufficient tests, the attempts to test these, but I think if it's framed properly, I think there might be something to go on there. Yeah, that's really about it. Yeah.
I think the resolution of all these kind of issues is not in the writing of laws or introducing new laws, no, because that's always very limited. What we need is the bigger argument, the bigger resolution, no. For example, I mean, I totally agree with common law should be applied more in Sarawak than as is been done here. We need statements in the constitution or in the general consensus whereby indigenous rights are recognized, or some kind of overall big rule whereby any other law that comes after it has to comply with this overriding principle. And in the constitution of Papua New Guinea, for example, it's very clearly stated 95% or 96% of all lands belongs to the native peoples there. Something like that, is it? And so on.
I think I just want to add to that. What Colin said is very true. Like, for example, in Canada, the I think it was in 1982, they had a referendum to actually amend the constitution to recognize the rights of Aboriginal peoples there, and post 1982. There was a big difference in terms of rights accorded, because there was a consensus built amongst the people of Canada that Aboriginal rights would be recognized. They were recognized prior to 1982, despite common law rights were recognized, but that the cementing of the rights in the Constitution really helped. That statement really helped. The rights, basically, the sort of spectrum of rights expanded after the 1982 amendment. And you wouldn't find the judiciary so apprehensive, because the constitutional intent is so clear. The will of the people is for the recognition of these rights. Clear and unambiguous statements, in the Constitution. Things like that would really help, especially even in court cases, as you would know, Clarice.
What are the existing legal protections in place that actually guarantee the rights of the Orang Asli in Malaysia?
There's very little legal protection for Orang Asli in terms of let's say land rights, for example. No, in the law itself, if you go directly to the Aboriginal Peoples Act, it says yes, the government can gazette certain areas as Orang Asli reserves. At the same time, the government can take it back at any time they want, no, without having to pay you compensation. No, may pay you compensation, but there are other laws. There are other laws where the Orang Asli can use to extract some kind of protection. No, for example, in the EIA, if a big project is supposed to be what do you call it, done conducted in the particular area, there are provisions in the EIA that require local stakeholders or local communities' participation or involvement or consent. And in standards like the Malaysian Timber Certification Council and the Roundtable on Sustainable Palm Oil, there are also standards, criteria and standards which require free, prior, and informed consent of the communities involved. See? And so all these things are there. And if you look, I mean, I was very concerned. I was very happy to see the Adana Properties, what do you call it? The Bunsom, what's the name? Bunyamid case or whatever. Remember the decision whereby the federal court reviewed and overturned a number of that particular case where fraud in the land office, can be reversed, can be protected, can be used to allow people to get back their rights to the land. It's not being used in the Orang Asli context, but I think this is some other areas where we need to look into, whereby a lot of land Orang Asli lands, traditional lands, are being sold, transferred, alienated to other people, precisely because of fraud in the land office. So we have to look at all these kind of things. But there's no one clear law that says Orang Asli have right and you can do this for this. You just have to apply this particular act and you can get your rights. No, you have to be very imaginative and go through all these other things, which is really a hassle.
I'll just expand on what Colin has said in terms of the laws available. Just take a couple of minutes, if that's okay. Right. I think this also stems from Mahadi's question as well earlier, and Colin's response on non-recognition. Now, when Colin says non-recognition, we must take it in context, right? So there exists welfare constitutional provisions in favor of the Orang Asli, Peninsular Malaysia Orang Asli, and these include empowering government affirmative action for the protection, well-being, or advancement of the Orang Asli. For example, that's in Article 85C, which is the equality provision. But one must understand the wording is such that it places discretion on the part of the government to determine when to legislate for the protection, well-being, or advancement of the government. So they are not rights strictly speaking, justiciable rights per se. They are justiciable in one sense, but it is really up to the government to determine the provisions for the protection, well-being, or advancement of the Orang Asli. And this protection is lower if compared to the special privileges afforded to ethnic Malays, natives of Sabah and Sarawak. So, for example, Orang Asli are not covered by Article 153, which most Malaysians would be aware of. That's the special reservation of quotas for Malays, natives Sabah and Sarawak. So Orang Asli are not covered under Article 153. They are, I think, as pointed out by Shereen, their religions are not explicitly recognized in the constitution. And customs, for example, Malay customs are covered in many provisions of the federal constitution, but this Orang Asli customs are not recognized, not given that explicit recognition as such. And I think Colin mentioned land reservations as well. Land reservations, rights of protection in respect of land reservations are also lacking compared to those afforded to the Malays under the federal constitution. As for the Aboriginal Peoples Act, there are many provisions. I think Colin alluded to some of them that confer extensive and excessive powers in some cases and control over the Orang Asli, their traditional lands and their lives as well. In fact, I'll just highlight one. One would be the minister currently in charge of Orang Asli can determine whether a person is Orang Asli or not. If that's not control, I'm not sure what is. And of course, and then the state authority also has a power to declare under the Aboriginal Peoples Act to declare revoke Aboriginal reservations. Despite having this power, they only a small percentage of Orang Asli lands are protected. I think of officially recognized lands, it's only about I think it's less than 30% at this stage, and actually Orang Asli lands are much larger. They're probably about 5 times larger than the officially recognized lands in the first place. So the government sees these lands as state lands for other uses, for example, forest reserves, and for others to use. So in such cases, the primary recourse to Orang Asli is to go to court. Thankfully, the courts have recognized rights of Orang Asli to their traditional lands, but the court itself poses challenges. And the very state governments who are supposed to protect the lands strenuously oppose the claims by the Orang Asli, and they often work together with business concerns to refute Orang Asli claims. Of course, the good news is that Orang Asli have been successful, but the bad news is that Orang Asli just don't have the resources to spend lots of time and money in courts, and the procedure in the court also does not suit them. Just a quick point. The Aboriginal Peoples Act, actually, if one were to look at it, there's plenty of legal commentary on it. You can just Google it, and I've written about it, and plenty of others have. It has actually functioned as an enabler for control, denial of self-determination, of Orang Asli self-determination to chart their own destiny, and it's a platform for integrationist policies and also for potential abandonment of traditional culture.
You did mention some of the court cases that were ruled in favor of the Orang Asli. Perhaps can you briefly just mention what they are and what are the rulings?
The court since 1997, I think, it's 1997. They have actually ruled. The courts have recognized the rights of the pre-existing rights of the Orang Asli to their customary lands that they have inhabited, at common law. Well, what that means in short is that they have recognized the I think Colin mentioned that the Orang Asli had their legal systems before, their own customary legal system. The courts have recognized the continued enforceability of these rights, and that these rights are enforceable in the courts, notwithstanding that those lands have not been gazetted or protected under the Aboriginal Peoples Act or the Land Code or titled under the Land Code. So it means that if an Orang Asli community has historically occupied or inhabited a tract of land, they can actually establish rights, but through the courts. And the second thing, there's a second element to that, and these are contained in the cases of Adong bin Kuau, Sagong bin Tasi, and Muhammad bin Nohing. These are the main trilogy of cases. Then there's the Malaysian courts have also ruled, recognized that the federal and state governments owe a fiduciary duty to protect Orang Asli land rights and not to act inconsistently with such rights. And that ruling has been there since 2005, and many Orang Asli communities, in the case of Sagong Tasi, and many Orang Asli have enforced this. Communities have enforced this in the court successfully. But as I said, the court is not the answer to this, because there are limitations in going to court as well in terms of proof, process, and also resources.
Yogesh and a number of very good lawyers, no, have been involved in a number of cases. I personally have been involved in 9 of them. They must have been much more. And some of the decisions made by the courts in our country has been quite very, very encouraging and very, very positive to Orang Asli rights. To the extent that, for example, in the Burra case, no, in the Muhammad Nawing case, the judge ruled that the creation of a Malay reserve land in 1927 did not extinguish the native title rights of the Orang Asli under common law. So cancel the Malay reserve, replace it with the land somewhere else, and then create that, gazette that area as an Orang Asli reserve. Then you got another case, in the Kochiwai case in Center in Bido, no, where a land had already been alienated to a company. And then because the land had been alienated, they sent a letter of eviction to the Orang Asli to get out of that particular lot of land. See? The Orang Asli countersued and argued that it was customary land. And the judge ruled that that alienated land under the National Land Code was wrong, but something wrong done by the state, and ordered the state to cancel that land alienation and give it back to the Orang Asli. Then you got other cases like the what do you call it, the Endau Rampin National Park, when parts of it, where the Orang Asli claim as their traditional lands, were recognized as Orang Asli lands, give it back to the Orang Asli. We got the forest reserves and catchment areas in Kelantan. So we have very, very good judgments, precedents, in all this, in some cases here, which actually indicate that Orang Asli do have rights under common law, and based on our constitution, and we want to keep that momentum and preserve it at that end. The problem is, as Yogesh would probably tell you, is that now a number of new cases are coming on, which have the tendency to become like a TR Sanda case, no? Negate the whole advances made by our lawyers here.
Yeah, I think for my part, I would like to add a few with regards to the Aboriginal Peoples Act. This is pertaining to the naming of the Orang Asli children. So because if you see, right, there's so many confusion about Orang Asli children. For some reason, some Orang Asli who are not born a Muslim are given bin or benti, and some of them, they are not having a interracial marriage, are putting anak perempuan or anak lelaki. So by not having this kind of provision in the Orang Asli right, is actually how to say, have a slight repercussion for the Orang Asli children after they grow up. For example, my case, I have a benti in my name, right? Even though I'm not a Muslim, so it's very hard for me to work at the workplace that actually not hiring a Muslim. So yeah, I think if there is a new amendment for the Aboriginal People Acts by actually define the naming of orang Asli children, just put it as a anak kepada, or just the name of the children to and the name of the father, should be okay. This have to be done in order to preserve the identity of the Orang Asli themselves, to make them feel proud to be an Orang Asli. And another thing that I would like to touch on pertaining to the appointment based on the Section 5 or the Act of the Act 134 regarding to the JAQUA Director and Vice Director. I believe compared to last time and now, there should be the right time now to actually amend this section with inclusion of one more section that stresses this position should be held by only an individual with an Orang Asli background. Alright, so I believe that after 2000, there are many qualified Orang Asli themselves who actually graduated from the local and overseas universities, and even those who have been in the public sectors for a long time. By allowing Orang Asli to be in charge of the JAQUA, to head the JAQUA, it will actually help to align and help to make the process of helping the Orang Asli people more successful, because they themselves the Orang Asli, and they want to help out their community instead of putting another race to actually heading that department. And another part that I also would like to stress up, there should be some amendment about the interference from the Ministry of Rural and Regional Development, whereby basically in the section 16 of the Act, it said that the ministry can actually hire and also, how to say, memecat mana-mana ketua of Orang Asli from their position. Because this is what the Dr. Yogi mentioned earlier, is this kind of thing when the Ministry of the Rural Development have some saying is actually cause that kind of conflict of interest, because it actually give a leverage to the minister if the chief is not from the same political party as him, and if the chief of the village actually against the minister work to develop his settlement. So yeah, I think this is some kind of amendment that should be introduced to help straighten up the Orang Asli rights in the Orang Asli Act.
Thanks, Shereen. You're very right in most cases, no? But there are 2 points I need to explain. One is the appointment of the head of the Department of Orang Asli Affairs, or JAQUA, to be an Orang Asli. I quite disagree with that. That was something we've been promoting for a long time. In the beginning, we said the Orang Asli department should be headed by an Orang Asli. But after we have had a couple of Orang Asli deputy director generals and generals who were terribly against the Orang Asli themselves, having come up through the government system, right? We feel that it doesn't mean just because you have Orang Asli blood, you are the best person for the job. In fact, the first commissioner for Orang Asli, the first director general, Dato Baharon, himself was an anthropologist. He protected and defended Orang Asli rights very much more than all the other Orang Asli could have done at that time, no? In terms of stopping religious conversion and ensuring development and so on. So it's not a case of whether you have Orang Asli blood or not that qualifies you to do something good for yourself, for the people. See, you have to have the right person with the right heart, with the right intention. Secondly, the thing about naming, I totally agree with you about naming of children. See, the Binti and Binti. In fact, at one time, the Orang Asli Association did suggest that for Orang Asli, the name should have the word, let's say, Shereen, Aslee, Ajani. No, because if you have AP and AL, people will think you are, what do you call it, Indians or from Sabah and Sarawak. No, for Sarawak. No, so they suggested the middle term Asli, so it clearly identifies you. So this is a classic case of the Orang Asli's rights, Orang Asli's right to self-determination not being recognized by the government. The people up there still dictate what you should be called and how you should be labeled.
When Dr. Yogi mentioned about the fiduciary duty of the federal government to protect the Orang Asli, as being one of the good news or one of the good development that we have in the country, but we have yet to see any significant changes, since that were discussed by the court. And I remember there was one particular case where the federal government during the PH government sued the Kelantan state government, but until now we do not see again that there's not much has happened. So I still think that even though they claim that they have that duty, but the government have not done much in that front. Can you comment on that?
The first thing I'd like to say is that the government has really never conceded that it has a duty to the Orang Asli in terms of protecting land rights. In fact, they always push between the federal because the background is quite straightforward. Federal government has jurisdiction over Orang Asli, whereas the state government has jurisdiction over the lands. So the federal government and the state government they basically push the blame to each other, but never concede. I have never seen a case where they've conceded that they owe a fiduciary duty. They have been forced to acknowledge their fiduciary duty by the courts. But so now I'll address your question. Unfortunately, as I think you know, you have said, there's been no development since then, and this is the problem. You have a government, a federal and state government, who have been ruled to ruled by the courts to owe a duty to the Orang Asli people in respect of the protection of their land rights, and to do acts not to do acts inconsistent with their land rights, and yet you see this happening so regularly. It is really disappointing on the part of the federal and state government. It seems that they are not happy that duty has been it would seem that way to me, that they are not happy that this duty has been imposed on them, because in other jurisdictions, when courts have decided in favor of recognizing rights, the legislature and the executive immediately legislate to recognize the rights, because the courts have recognized, the highest courts have recognized these rights. But we have not seen anything like that happening for the past since Madeli, which is coming up to 15 years. There's been no action whatsoever. What I'm afraid of is that it may end up like the situation in Sarawak, where the Sarawak government did not legislate, waited they did not legislate to recognize common law rights. They repeatedly contested cases brought by the natives of Sarawak, and the case and one of the cases, or a few of the cases, ended up going to the federal court. They got the right panel, and some of the gains were reversed, as Colin mentioned. So I hope that's not the strategy. It's not for me to say, but I just hope that's not the strategy, because that's really not a good thing. Because if you these it just means that you have no intent, no political will whatsoever to recognize these people. These people, meaning the Orang Asli, and their rights. So that is a concern. Yes, you're very correct in pointing that out.
Can I just add to the last question, Pahadi? You asked about the federal government's case against the Orang Asli, against the Kelantan state government in favor of the Orang Asli of Post Simpor. That case has now been closed because they lost at the Court of Appeal, where the judge ruled that there was no provision in the Constitution or any written law that recognized the local standi of the federal government to sue on behalf of Aboriginal people. So the federal government cannot sue a state government on behalf of the people, basically that. But the Orang Asli are given the right to restart the whole suit again and sue the government in their own capacity.
In Australia, I understand the Aborigines have been pursuing recognition in the Constitution where they're not recognised. One of the discussions has been about whether there should be a preamble to the Constitution that recognises Indigenous rights. I'm just wondering, because Malaysia does not even have a preamble to its federal constitution, I'm just wondering if that's a possible strategy or if it's been thought before, if there's any use in that. But it's just something that then perhaps starts getting the government thinking about having the right philosophy, a positive philosophy, without immediately making them legally obligated. And then it also means that the courts are on notice too, that there's more likely to be a change of direction in society. Malaysia at the moment, like all countries, there's a lot of question marks, a lot of things to think about. I just wondering, and it may be a situation where you need to combine with people in other types of issues. For example, people who are looking at constitutional or other areas of government reform. So, that's really what I wanted to raise about recognition under a preamble in the Constitution.
Right. The problem. Well, I see a couple of challenges. Although I think offhand it's really a good idea, because so far I've seen a lot of memos, and we'll talk about that in the next session for reform. Not many concentrate too much on the preamble, but the preamble basically, I would say, and you would understand this, Simon, as a law teacher yourself. The preamble necessarily means a sort of rewriting of the history, if you like, of the Constitution. Now that's where you might have challenges, because it might actually question the predominant narrative, because we have a narrative that before how the Malaya gained independence, how the Constitution was written, and then how Malaysia was formed with that constitutional background. Now, to include a preamble that specifically addresses indigenous rights, may well encounter opposition, and I don't think there would be a real legal basis for it as such because it's a preamble. But um, I would think it's a good idea to actually start advocating the constitutional recognition point. There is recognition, as you know, Simon, but it's just that a preamble, as many law students will know, indicates the in spirit. It can be read as part of the spirit and the intent of the Constitution. So, if any constitutional provisions come into question, one can look at the preamble in order to help interpret the Constitution, which is why it's key that it be included in the preamble. And some other jurisdictions have attempted that as well and done that. But I think, yeah, it would be an uphill battle. But what else is new for the Orang Asli anyway?
Is there actually a need for legal reform in this area? If so, why?
For me, in my opinion, there must be some sort of legal reform, especially the recognition of Orang Asli to their customary land. Because as far as you guys know, we don't really have a grant to actually, claiming that the land is ours, and most of the way that we have to show that we are the owners of the land is through going to the court, and based on the court cases. And um, so I think this very important to do some legal reform, not only for the Orang Asli ownership of the land, and also it's very important for Orang to have some kind of legal reform in Malaysia education system, because in Malaysia history textbook there very few stories about Orang Asli. There are very few story about how the Orang Asli also helps in order for the Malaysia last time to gain the independence from the British. For example, there's no a story about the foundation of the Senoi Prak, which is Malaysian Royal Army created last time to fight the communists during the Malayan emergency. And we have those people, those Orang Asli people, such like um, Chief Inspector Long, anak laki Panda, and Sergeant Major, anak Alang, who fought bravely, just like another Malaysian at that time, but sadly their name is forgotten. You can only know about their name if you really look into the history about the foundation of the Sunday Prague. And at the same time, I also feel like the legal reformation is very necessary and very pivotal to bring the Orang Asli to actually move forward and able to see themselves to, how to say, um, improve their economy as well. Because if there is no such a legal reform taking place now, the Orang Asli will be forever seen as poor, marginalized community, uneducated, and their rights to the land will always be ignored, and there will always be issues about Orang Asli land being encroached by the illegal loggers. And all these kind of problems, which at the end will make the Orang Asli lose their identity as the real indigenous people in Peninsular Malaysia. Um, as there's not much written about history in school textbook, and the young generation born after, maybe 2010 will no more practice their culture, tradition, and unique mother language due to lack of preservation in it. So for example, while I'm interning at the New Zealand High Commission, what make me amazed by the way the New Zealand government is because they have this ministry for the Maori development. It's called Tapuni Kokiri, where there in this ministry the government has sought to emphasize the importance of all the Maori participation in New Zealand society. And the New Zealand government also, they have these three prime responsibilities to the Maori in three key areas. The first is to endeavor toward the past Treaty Awatangi. So just to share, Treaty Awatangi basically it was a contract entered by the Maori and the Crown last time, whereby in this contract, how to say, the Maori people, they are giving their land to the it was made between the British Crown and about 540 Maori Rangatinga, which is Maori chief. And this contract now is actually help to establish the Maori ownership of their land now. And another thing that the New Zealand government is focusing is on their responsibility to retain and to promote the unique indigenous Maori language and culture by promoting in the tourism sector and also preserving the language in the schools. And the last thing is they also try to involve, to empower, and to raise average Maori achievement levels as above what Maori are, so that the Maori people are equal to the rest of the New Zealand society, which means that they always put any Maori for their policy, especially in the economic, because from the having a good economic policy, it was actually empower the indigenous community themselves. They will be more self-reliant. They will be able to see themselves compete with other races if they have that kind of economic power.
Before we can have any kind of legal reform or even advocate towards getting some kind of reform towards that in that direction, we need to understand what we're talking about, who we're talking about, and why. So first of all, I have to clarify that we in the Center for Orang Asli Concerns do not fight. No, do not advocate for all Orang Asli. We only advocate for those Orang Asli who are still, in a way, practicing the traditional way of life, or want to practice the traditional customs and way of life, but are prevented from doing so because of various factors. We're not talking about the Orang Asli who are in town, who are bank managers, who are we have housing problems and so on. They are no different from any other Malaysian. So we are talking about a category of people who have a certain requirement in order for them to live dignified and what do you call it, full lives, and that includes the connection to the land, or the control over the land. And it's not just land; it's a specific geographical space, a specific ecological niche, which they call the customary land, tanah adat, Nenggrik, and so on. So every Orang Asli community is linked to one particular geographical space, and Orang Asli does not have rights to any land. They only have rights to their customary land. And Orang Asli in Johor cannot go to Kelantan and say, I'm also Orang Asli, therefore I also have rights. No. So that has to be understood, because the identity, the culture, and everything else comes from that particular connection to that particular land. Okay. So based on that, we strongly feel that Orang Asli of the type you're talking about, or the people you're talking about, have specific rights, and that right is very, very clear, in international law and so on. It's like this, a disabled person, if he cannot walk up the stairs, he has a right to have something done by which his passage is made easier. But not all disabled persons have the same problem. Others have loss of sight, or loss of hands or whatever, but not all have loss of mobility, you see. So we have to look at it in the same context, So if the Orang Asli, they need their customary lands in order to be Orang Asli of that particular community, of that particular ethnic group, in order to live dignified and full lives. So everything else that comes into play, the reforms that are needed. Yes, you need legal reform for the land rights, because you have to protect the lands. You need reform for the rights to practice their customs and institutions in that particular area, as if it was a self-determined sovereign nation, autonomous nation to some extent. So once you understand that, and you understand that it's not a question of Orang Asli impinging on other people's rights, because they are not taking other people's lands. They are living on their own lands, which at the moment, at least, nobody else is claiming as just. Then if you practice or you apply the principle of diversity, which Carl Elias Hanisham was talking about, then we have to have a diversified country with diversified communities and peoples living in it, with diversified needs and rights, which should be guaranteed in the constitution, in the laws, and so on. So that's where I think we should first get our act together.
Is there a need for legal reform? I would say there's little doubt that the law is in desperate need of reform. And 60 years of stewardship that the government has had over the Orang Asli, the state governments, in terms of land, and the federal government in terms of Orang Asli welfare has not uplifted them to a satisfactory level to them and also to onlookers like me, right? While the law, I think may not be the driver for the issues faced by the Orang Asli, the law has certainly and continues to certainly function as an enabler of policies which dispossess and marginalize the Orang Asli. An unjust law, I would say, that remains in force validates his authority, lessens incentive for change, and in practice legitimizes injustice as the norm. So the injustice becomes a norm, you know. So of course, reform must, we don't have to reinvent the wheel when it comes to legal reform. I think the Suakam report was mentioned many a time, a couple of times today, has been mentioned, many a time and a couple of times today. The Suakam report, National Inquiry Report, 2013 report, actually has 18 recommendations in respect of Orang Asli land right. 17 has been approved by Cabinet, Malaysian Cabinet in 2015, but we've not seen too much action yet, in terms of reform and changes. There's also the 136 resolutions from the National Orang Asli Convention of 2019 that was held in Putrajaya and organized by the then Pakatan Harapan government, and where there were 7 focus areas: land, education, health, economy, leadership, infrastructure, and culture. Lots of points and recommendations made there. But in short, these recommendations relate to increased recognition, empowerment, meaning self-determination, and priority for Orang Asli and their customary land rights, and of course protection in the form of free, prior, and informed consent. Now this is where I think Colin's bigger question comes in. Effective reform is not about just amending a statute or having a new law. The mechanics are quite straightforward, but it would necessarily include a recalibration of socio-political mindsets and narratives and broader economic priorities. And I'll just finish off with a couple of points, explaining this. All of us need to, even me daily. It's whenever I meet the Orang Asli, I learn something new about them. And everybody needs to undo the historical prejudice and preconceptions and ignorance and racism that they have against the Orang Asli, who are in one way or another and to one degree or another viewed as backward. And some view them as less backward, some view them as backward economically or whatever it is. That needs to change. And we need to undo the need to make them live like the rest of mainstream Malaysia. We should look at areas like the reform should look into areas like self-determination over paternalism, remedying injustice as opposed to looking at benevolence like it's a charity work that you do. No, it's an injustice that needs to be corrected, and look at them as people, not marginalized people, but people who have been marginalized by us. That's the first thing. The second thing I would want to add, second point of the 3, is that one must look at releasing the legal stranglehold over the Orang Asli to enable Orang Asli self-determination, releasing it gradually and progressively. The third, of course, is the economic priority for resource extraction and land development for industry and cash crop cultivation. This is a real challenge for law reform. A law reform that recognizes and respects the rights of Orang Asli to their relatively, for example, large customary areas. This requires a change in mindset and an acceptance at a policy level that Orang Asli philosophies and practices of reciprocity and respect for their traditional areas contribute substantially to sustainability, the regeneration of our environment, not their environment, our environment, and also our economy. The legal recognition, if there's such legal recognition, the legal recognition of such stewardship of their traditional area and them as equal partners in the management of these areas would have to be seen as beneficial and perhaps even necessary, rather than being viewed as backward, an act of charity, regressive, or even a hindrance to economic prosperity.
I do want to point out one that you made earlier on in terms of the resolutions and the recommendations introduced by Suhakam and as well as the relevant Orang Asli organizations. So you did talk about them putting all these recommendations forward, but how likely do you think all these reforms, right, can be effectuated in the near future?
I think this question is a question of, again, now it's been repeated to the point of exhaustion. It's basically this political will, because Orang Asli at the end of the day, they'll probably remain politically and numerically weak for the foreseeable future. So what is it? I think there needs to be, and I've said this before, there needs to be some catalyst for this new beginning for Orang Asli in terms of rights to substantive equality. We don't know what that catalyst could be. It could be political and public perception. For example, that Orang Asli votes matter. It could be public perception that Orang Asli issues are closely linked to national issues such as environmental degradation and require immediate action. We've not seen that. I've not seen that catalyst yet. That's the unfortunate part. And believe you me, once that happens, just like what happened in Australia, once there is that catalyst or there is that impetus, reform will happen very, very quickly, surprisingly quickly. It'll be shockingly fast. But it hasn't happened. I don't know. I haven't seen it happening just yet.
My question is directed at Dr. Colin. And correct me if I'm wrong, but you spoke just now about the differences, or perhaps the differences in representation of a specific set of Orang Asli who continue to actively practice their custom of foraging, hunting, and cultivating, as opposed to those who have left their longhouse or their kampong for study, work, or essentially the comforts of modern living. My question is this: should there be a line drawn, in terms of legal reform at least, between the suburban Orang Asli and those who still live in the quote-unquote rural areas? Now, I ask this question because there are two cases, one in the High Court in Sarawak and the other in the High Court in Pahang, that have recognized that native customary rights, particularly of like foraging, hunting, roaming in the jungle, these rights are not to be given up despite having all the comforts of modern living, or like maybe even if they're wealthy and they've moved to civilization, so to speak. What do you think of that?
I'm not saying that Orang Asli should remain in the forest and hunt with the blowpipes and go fishing for their food and so on, no. And only if they are classified as that, then you are Orang Asli, as defined or as understood by us. But what I'm saying is that the Orang Asli dependence on the land. So that dependence on the land could be, yes, your foraging and hunting rights, or your dependence on it to grow oil palm or rubber, but that's where you get your subsistence, your income, and so on. Your dependence on your land. And secondly, the integrity of the area. The area must be very well defined. This is your boundary, your customary land. This is your extent of your customary land. This is the content of my customary land. It is my customary land because, as they say, it's your supermarket, your archives and so on, because your data are buried there. You know where, the history and all the stuff. So you know your territory. It's like a country, basically a small country. And as such, and the land is used differently. Just like how in a housing estate you got land for houses, land for your surau, land for your playground, and so on. Similarly, for the Orang Asli, the land is also used for various various land use zones, no? For your farms, for your fields, for your houses, for your recreation area, for your catchment area, for your protected areas, for your sacred areas where you can't enter and so on. So all these things is like a small territory which define that people of that particular area. So when Orang Asli become, stay in towns and get, live a new different lifestyle, they are still Orang Asli. They still have rights to their identity. They still have rights to their, what to be called and so on. No? But in terms of land rights, they cannot say, I'm now staying in PJ, therefore I have a right to PJ because, PJ was a long time ago part of Orang Asli land. So it's a different thing altogether. And secondly, you have to be identified by your community as a member of that community also. So the whole issue of identity. So you have to make it. I have to make it very clear that when I talk about Orang Asli communities and defined by the law, we're talking about these distinct communities, distinct cultures, distinct communities, distinct areas.
Perhaps a follow-up question from that. Then how would perhaps the next generation of Orang Asli children, for example, those whose parents have already perhaps migrated to the suburban areas and are born in the suburban areas, how then would they establish their connection with their quote-unquote ancestral lands?
Yeah, so it doesn't matter where you're born or where you're living. As long as you're connected, you still have land, you still have connection, you still have relatives, you still follow the practice. When you go back to the village, you're still a member of that community, following the adat and so on. So it's not as if that once you leave the land, that you no longer live in it, you no longer have access or a member of that community. Much like how you are a Felda settler, and then once you have got educated and so on, it doesn't mean the Felda is no more your homeland or your land and so on. No, so it's like that. It's your connection. It's not your physical presence on the land, your physical occupation. It's your connection to the land.
I think just two points. I think Colin was making essentially that the person who's staying, we just pick out the particular, because you picked out a particular instance of a person staying in the in a suburb, in the urban area, who's got a job, as a lawyer, for example, and there's no reason why that person can't be a member of a community that possesses customary rights in say, if he's in Kuala Lumpur, he can't be. There's no reason why he can't, and he's connected to that particular community. There's no reason why he can't have customary rights to that particular communal customary rights to that particular tract of land. That's I don't think that's anywhere in firstly the cases, and I think by adat also, I think it should not be too much of a problem as long as the community accepts you as a member.
So my question is follow up on Yoges's question, and this is pertaining to the game-changing event that he is predicting, right? That would because all that we've heard and has been practiced over the past 20 years has been trying to find justice and fairness in the courts, right? So the question that I'm saying is that, all right, so now it seems that the buck stops at the state level, and what would it take? Let's say that there was political will in a hypothetical scenario to to sort out land issues, not the duking it out one at a time thing, but on a overall some sort of a registration / regularization process. What would that look like in a hypothetical sense? Okay, that's my first question. The second question is Yogesh, you mentioned this business of the environment, right? So those who know me understand that I've been advocating for indigenous rights in the context of conservation and protected areas. In the national policy on biodiversity, there are also people who've ensured that indigenous and community conserved areas as a concept are incorporated there. How can we continue to push this angle? OECMs, other effective area-based conservation measures, is another way to represent local laws without having to actually have title per se. So what are your comments on how other angles to try to attack giving people more access to resources and self-determination?
Right. Firstly, I didn't make a prediction. What I did, I'm merely speculating, because it's very hard to predict how this thing is going to unfold. This whole story is going to unfold in the end, if it ever ends. because you can go back 120 years and look at some British government documents, and you will find them talking about the same things we are talking about right now. So we're not sure what's going to happen. So but of course, I did point out a couple of scenarios. I would say, it really depends on what happens, what that particular tipping point is, if you like, um, if it's the need to recognize Orang Asli lands, and that's the priority. Unfortunately, it could result in environmental issues perhaps taking a slightly back seat, a back seat. So you might get communal ownership, for example, of large tracts of Orang Asli land, But if it's a bit more balanced, it may take the form of co-management agreement for protected areas and perhaps communal ownership for those areas that are already settled by the Orang Asli. So there are many models out there, but it's so and there are many experts out there too who can propose models. It's just that it's so difficult which direction the the government is going to take if and when they ultimately decide to resolve the land issue, the Orang Asli land issue. I am for co-management sort of arrangements as well, because I've been in discussions before where it appeared to me that it would be completely unreasonable, for example, to grant a title for an entire national park, for example, to the Orang Asli for a complete national park. So what do you do as an alternative? And as an alternative, there are a lot of these conservation areas that are being tested out, in Malaysia and elsewhere, which apparently do work. So those models should come in. But I think, in short, whatever that's being advocated now needs to be done in a very concerted and holistic manner, rather than environmentalists say pushing their own interests and then push, sort of not prioritizing the Orang Asli, and Orang Asli pushing their own interests and perhaps not looking at environmental concerns as such. So I think working together would help.
Justin, you mentioned something very important. No, is preparedness. No, if so, the problem I'm facing with and our friends are working on, no, is if this game-changing event does happen, say next month, next week, or next year, are we ready for it? No, are the people ready for it? No, what resolutions do the people have? No, the Orang Asli people have. So that is an issue which we are still working on. In for example, the national strategy on land, territories, and resources, but there have also been some developments. No, for example, I remember working with Lim Heng Sing from Lee Shamuddin. In 2008, we presented to the Selangor government when Selangor government was under Pakatan Keadilan at the time, and drafted the native title land State of Selangor enactment. So basically, a law, a bill, no, written in very legal language. What do we call it? Parliamentary language or state assembly language, already drafted, meant to be submitted to the assembly and exco, but then there was a change in leadership from Khalid to Azmin, and the whole thing was dropped. But so in that draft native title land enactment, we have provisions for a tribunal for resolving disputes. We have this whole arrangements of collaborative management or co-management of forest reserves and so on. So it was a very detailed land. So we have it already. It's a matter of waiting for the game-changing moment to happen, or somebody up there to come up. Like in Sabah and Sarawak, Sabah especially, ICCAs, the whatever indigenous conserved areas, are accepted. But because the forest department there is very proactive. Here in Malaysia, you try and do it, although we have a couple of projects on ICCAs in Peninsular Malaysia, no buy-in by the forest department. So it all depends on getting the right person at the right time or not in charge of these people, this what do you call it, these agencies or these game-changing bodies. No?
Just a quick point to that. The legislation or draft legislation mentioned by Colin, actually it forms part of the 136 recommendations made during that national convention too. So all these things are actually already there and put in place, but we are just not sure what the government is going to do and which sort of line they're going to take, and perhaps we should be open to that as well. But if you're talking about a Pakatan government, what's been given to them is quite clear. It was all ready to sort of, in a way, it's just for sort of implementation, acceptance and implementation, but that of course turned pear-shaped.
For you growing up as an Orang Asli in Malaysia, what message would you like to send to all Malaysians, considering all the issues that are currently plaguing the Orang Asli communities? What message would you want to make clear to all Malaysians, Shereen?
So basically, it's just simple. I think the most important part is just to recognize us as one of the Malaysian as well, and respecting our traditions, our culture, and not making any derogatory remarks. For example, calling Orang Asli as Jakuns, Sakai, because this kind of thing is actually um, will lead to some form of racism, which I believe is racism is actually something that being taught by the parent to the children, not something that they have when they grow up. And this kind of racism also, how to say, the repercussion from this kind of racism that the Orang Asli suffer in that school, which make them, a lot of them drop out from the school, and left behind from education. And at the same time, I would like the Malaysian to know that the Orang Asli are just the same like you guys. We are still the same human being. We are we are nothing different. The only thing is, we might be a little bit left behind due to the most of the time. Last time we living in the jungle in the forest, but now I can see that many of Orang Asli, they are university graduates. Like in fact, even now joining us, we have Chai Mei Miss Chai Mei Ling and Miss Suzy Lin Suki. They are also just joining for the Parlimen Wanita Muda, and they are actually learning how to be um, how to be representative of Orang Asli for their parliamentary seat. And we also have our young Adriana here also joining this conversation today. And Adriana is just only 17 years old, very bright Orang Asli student, and she also joined that particular program. So I feel happy to see that most of Orang Asli nowadays, we are able to see ourselves not to be the person that being oppressed, but more into the person that leading their community. So I think that's all from me. Thank you.